What's happening, everybody? So if you're studying for that real estate exam, I've got you covered once again. Here are 25 high impact practice questions with answers and explanations for the national portion of the examination. It's good for all the states. Let's get right into it. Question number 1. At a local real estate association meeting, several competing brokers complain that agents in the area are charging increasingly low commissions. The brokers agree that none of their firms will accept listings for less than 6%. This agreement is best described as letter A, a monopoly. Letter B, price fixing. Letter C, redlining. Letter D, market allocation. And the answer? Letter B, price fixing. Okay, so commissions are fully negotiable between the client and the broker. This is something fundamental that you will always, pick up on as you're practicing and learning about this stuff. So commissions are always negotiable. And the brokerage industry is subject to antitrust laws. Now, the type of violation in antitrust that this correlates to is price fixing. Competing brokers may independently determine the compensation that their firms will charge, but they may not agree with one another to establish a minimum, maximum, or standard commission. Absolutely something that you want to know the definition of. So the Sherman antitrust or the antitrust questions definitely show up. There's not an abundance of them probably. You're probably going to see like maybe a couple, but they're easy ones. And if you can nail these, you're good to go. So remember, this is called price fixing. This is a violation to the antitrust law. Question number 2. What is the most common use for a CMA in real estate? Letter A, to estimate a home's assessed value. Letter B, to estimate the cost to rebuild a property. Letter C, to estimate a home's fair market value. Letter D, to determine the property's appraised value for financing purposes. And the answer? Letter C, to estimate a home's fair market value. All right, so a comparative or competitive market analysis is an evaluation conducted by a real estate professional to estimate the value of a property by comparing it to similar properties that have recently sold in the same area. Now, we are going to be performing competitive market analysis or comparative market analysis to solicit listings. They are not to be confused with an appraisal that is performed by an appraiser, but they do give an estimate or an opinion of value. Assessed value is used for property taxes. Let's remember replacement cost estimates that would be cost to rebuild the property. And the appraised value is determined by a licensed appraiser, and that's always something that you want to know, usually for financing. So it estimates a home's fair market value, and primarily I'm just going to write in here for listings. So you can get a value check before you list with a company. Question number 3. A couple with 2 young children apply to rent an apartment in a building with an unfenced swimming pool. The landlord refuses the application, explaining that the property is not safe for children. The applicants otherwise meet all financial and rental requirements. Which statement is most accurate? Letter A, the refusal is legal because of a legitimate safety risk. Letter B, the refusal is legal if the landlord applies the rules to all applicants. Letter C, the refusal is illegal because the landlord is steering the applicants. Letter D, the refusal violates the Federal Fair Housing Act because familial status is protected. And the answer? Letter D, the refusal violates the Federal Fair Housing Act because familial status is protected. All right, so the explanation here, the Federal Fair Housing Act generally prohibits discrimination based on race, color, religion, sex, national origin, disability, and familial status. Familial status includes households with children under 18, pregnant individuals and people securing custody of a child or children. Now, a landlord cannot avoid the law by claiming that excluding the children is for their own safety. The landlord should address the hazard itself, for example, by securing the pool, not excluding a protected class. Now, there's a little bit of a nuance here, and I'm just going to draw the line. Generally speaking, the way that question 3 was framed is generally speaking the answer, and those are going to be in line and correct. Now, if that same family applied for the apartment, they were denied because of the safety of the swimming pool, yet the landlord offered them another unit that was in a fenced-in area protecting the child, then safety is an acceptable condition so long as the approval wasn't conditioned on that alone. So you might see something more nuanced go into a question like this, where the test writer is really trying to expand your thinking a little bit and push you to see if this is acceptable or it's not. And the way that this question was framed, this question is the correct answer. It's D. The refusal violates the Federal Fair Housing Act because of familial status protection. They kind of framed it that way and led you there. So be careful when you're reading questions like this. And depending on who you're taking the course with, they might talk about that additional nuance. Now, letter A here, the refusal is legal because of a legitimate safety risk. There's not enough in this question that really opens up anything further. The unfenced swimming pool is now sort of this spotlight. It's a bigger problem. If the pool was fenced in, but certain units directly access the pool without a fence, then that could be the nuance. So just understand the way this is framed is correct. However, there could be more detail in the questions depending on the test writer that you're experiencing. Question number 4. Violations of the Fair Housing Act are typically handled by letter A, HUD, letter B, the FTC, letter C, the Office of Equal Opportunity, letter D, the Real Estate Commission. And the answer? Letter A, HUD. So HUD, by the way, stands for the Department of Housing and Urban Development. You want to know that? And so HUD is the enforcer, and they typically handle fair housing violations. Violations of the Fair Housing Act are primarily handled by the Department of Housing and Urban Development. HUD is responsible for enforcing the Fair Housing Act, which aims to prevent discrimination in housing based on race, color, national origin, religion, sex, familial status, and disability. You definitely want to memorize those 7 protected classes. That's pretty important. And also understand the differences between the ECOA and the Fair Housing Act, which you're going to need to know. So age, marital status, and the receipt of public assistance as well. Question number 5. A homeowner wants to build an attached garage, but the proposed garage would extend several feet into the setback required by the local zoning ordinance. Because of the lot's unusual shape, complying with the setback would make the project impractical. What should the homeowner apply for? Letter A, spot zoning. Letter B, zoning variance. Letter C, grandfathering. Letter D, annexation. And the answer? Letter B, a zoning variance. Okay, so a zoning variance allows a property owner to request limited relief from a zoning requirement when the property has a unique condition that makes strict compliance unusually difficult or creates an unnecessary hardship. So the prongs that you need to memorize or think about when you're looking at questions like this are those. Are there unnecessary hardships? And if there's a hardship and it's unnecessary, then what we can do is we can apply a zoning variance to the scenario, and it helps tremendously get this thing approved. Now, Here, the homeowner is not asking to change the property's zoning classification or its permitted use. The homeowner is asking for relief from the setback requirement because of the lot's unusual shape. So you want to know the fundamentals of zoning variances or conditional use permits. You will find these in the government sections of your textbooks where they talk about comprehensive planning, master plan, zoning, conditional use permits, etc. You're going to see it right there. Question number 6. A broker receives a buyer's $10,000 earnest money deposit. The broker places the money into the brokerage's operating account for 2 days before transferring it to the escrow account. No money is spent, and the full deposit is ultimately transferred. The broker has most likely committed letter A, conversion only. Letter B, commingling only. Letter C, both commingling and conversion. Letter D, neither, because the buyer has suffered no financial loss. And the answer? Letter B, commingling. Excuse me. All right, so commingling occurs when a broker mixes the client or trust funds with the broker's personal or business funds. Depositing earnest money into the operating account is commingling. So they deposited money into the operating account, so that is commingling all day long, even if the money is moved later and no loss has occurred. Conversion, on the other hand, occurs when someone wrongfully uses or takes the funds belonging to another person. So the test question kind of gave you that bit. No money is spent, and the full deposit is ultimately transferred. So it was a bit of an oopsie. They put it into the wrong account, or they put the money accidentally into the operating account for 2 days before moving it. It could have been the best of intentions. They had no intention, let's say, to take the money, but they did. They are guilty of commingling. And so when does this typically happen? Their financial records are audited. And when they're subject to audit, they might find that there's also these violations for commingling and conversion. And that's what's going on right here. So you definitely want to know these. These are popular on exams all over the United States. Question number 7. 3 unrelated individuals acquire property as joint tenants. One owner later sells that owner's interest to a fourth person without the consent of the other 2 owners. Which statement is correct? Letter A. The sale is invalid because joint tenants must sell together. Letter B. The new owner becomes a joint tenant with all remaining owners. Letter C. The new owner holds a tenancy in common interest while the original 2 may remain joint tenants with each other. Letter D. The sale automatically converts the entire ownership into a tenancy by the entirety. And the answer? Letter C. The new owner holds a tenancy in common interest while the original 2 may remain joint tenants with each other. All right, so a joint tenancy may generally transfer that tenant's individual interest unless, explicitly prohibited or expressly prohibited. The transfer severs the joint tenancy. It severs it as to that share only because the required unity of time and title no longer exist between the purchaser and the remaining owners. So there's a sort of initialism for joint tenancies. Many books teach it. It's called PIT. PIT stands for possession, interest, time, and title. Those are the 4 unities. That's the fancy legal term. 4 unities that establish a joint tenancy. They all have to be present in order for this thing to be acknowledged as a joint tenancy. So possession, we're all in possession of the asset at the same time. With an equal interest, joint tenancies are equal interest. Y'all need to study your co-ownerships. You'll see that in your co-ownership sections. Definitely learn right of survivorship, no right of survivorship, joint tenancy, tenancy by the entirety, community property, and tenants in common. So possession, interest, time at the same time, and it has to be titled on one document, listing everybody as a joint tenant. The minute you sever that or one of those items or unities, like you did here, the unity of time and the unity of title no longer exist, then the person that sold their interest, the new owner, becomes a tenant in common. and then the other two original remain as joint tenants. And so you want to know this. This is like a little bit of an advanced layer on this, but I certainly have seen this multiple times in lots of publications all over the United States. I'm pretty sure you're going to see something like this, maybe on the broker's exam versus the salesperson's exam, but look out for it. Question number 8. A type of freehold estate that comes with a specific condition for its use is a, letter A, non-conforming use. Letter B, fee simple defeasible. Letter C, fee simple absolute. Letter D, life estate. And the answer? Letter B, fee simple defeasible. Okay, so fee simple defeasible, fee simple determinable, fee simple on a condition subsequent, and fee simple absolute. These are the various types of freehold interests. In addition to that, we have life estates, per autre vie, and conventional. You want to study these, you'll see these. And the fee simple defeasible is a form of ownership that is subject to a condition set by the previous owner or grantor. So there's a condition here. Now, if the condition is violated, the property may revert back to the seller. So fee simple defeasible is the main category. These are properties. Where do you see this, by the way? This is all language that's in the deed. So fee simple defeasible is the category. So it's fee simple indefeasible versus fee simple defeasible, which is fee simple indefeasible is also the same as saying fee simple absolute. Fee simple defeasible has some kind of conditions. And then there's two subcategories, fee simple determinable and fee simple on a condition subsequent. You'll read those and check those out. But you want to know that defeasible fee estates have some sort of restriction. And if you break that promise, then the ownership may revert back to the grantor. Question number 9. Owner A owns a landlocked parcel. Owner A has a recorded right to cross owner B's property to reach the public road. Owner A later sells the landlocked parcel to owner C. What normally happens to the easement? Letter A, it terminates because owner A no longer owns the property. Letter B, it transfers only if owner B signs a new easement agreement. Letter C, it becomes a license that owner B may revoke at any time. Letter D, it passes to owner C because it is appurtenant to the landlocked parcel. And the answer? Letter D, it passes to owner C because it is appurtenant to the landlocked parcel. So, an easement appurtenant benefits one parcel of land and burdens the other. What I would do here is on the scratch paper or a little whiteboard that they give you at the testing center, just do a little drawing, right? Make a little doodle. And so in that doodle, you kind of scribble out these items. Who's owner A, which property is landlocked, etc. So the benefited property is the dominant tenement. In this example, owner A is dominant. The burdened property is the servient tenement. Owner B has to serve owner A to reach the public road. So owner B, you want to get this sorted, is servient to owner A, who is dominant. Because the easement benefits the land rather than merely a particular individual, it runs with the land. That's the phrase that you want to know with easements. They run with the land, which means every owner is either bound by this easement because it's in writing or is benefiting from the easement, depending on who the dominant tenant is as well, and transfers with the dominant parcel. It doesn't turn into a license or anything like that. So again, these are standard basically OG easement style sections. You'll see these in real property and law sections across the United States. Read them, check them out. Pretty simple, but you want to see stuff like this because you're going to see it on the exam. Question number 10. A buyer is considering two homes in the same neighborhood. The properties are nearly identical in size, condition, design, and utility. One is listed for $425,000 and the other for $450,000. the buyer chooses the lower priced property. Which appraisal principle is most directly illustrated? Letter A, contribution. Letter B, substitution. Letter C, conformity. Letter D, progression. And the answer? Letter B, substitution. So, the principle of substitution states that a knowledgeable buyer will generally not pay more for a property than the cost of acquiring a comparable substitute. So, we're talking about nearly identical in size, condition, design, and utility, and therefore, the purchaser purchased the $425,000 house versus the $450,000 house. And so therefore that is illustrative of the theory of substitution, the principle of substitution. All of these are very popular for examinations. You want to know these: contribution, conformity, progression, and of course, substitution. And by the way, substitution is the foundation for the sales comparison approach or the market data approach. You'll see this in your appraisal sections in your books. Question number 11. Which statement is most likely considered puffing rather than potentially being misrepresentation? Letter A, the roof is 10 years old but will last at least 20 more years. Letter B, there has never been a moisture problem and the basement is always dry. Letter C, this is the best house on the block because it has the nicest views. Letter D, the appliances are brand new and under extended warranty. And the answer? Letter C, this is the best house on the block because it has the nicest views. All right, so why? Puffing is the use of exaggerated or subjective statements that reflect a salesperson's opinions or personal judgments, not objective facts. This statement is clearly an opinion, not intended to be a certifiable fact. The other answers are presented as definitive, factual statements that, if false, could lead to legal issues due to misrepresentation. So again, just kind of taking a look at these, the roof is 10 years old, but it'll last at least another 20. Well, we don't know that. Again, that's a statement that could be misconstrued as fact. There's never been a moisture problem and the basement is always dry. That also could change. And then all appliances are brand new and under extended warranty. And so maybe we have an extended warranty, but they're brand new. And maybe I think what they were trying to do here with that particular statement was that the appliances are brand new, so therefore they must be under extended warranty because everything is brand new. Again, it's tough to interpret, but C would have been the best choice anyway because it's opinion and it was purposefully intended, or many could argue for just that, it's just an opinion, that it has the best views. Question number 12. A mortgage lender offers a real estate broker $150 for every buyer the brokerage refers to the lender. The payment is made regardless of whether the buyer ultimately closes, and the brokerage provides no actual marketing or other services in exchange. This arrangement is most likely, letter A, legal because the payment is made before the closing. Letter B, legal because the consumer is not directly charged. Letter C, prohibited by RESPA as payment for the referral of settlement service business. Letter D, prohibited only if the brokerage represents the buyer. And the answer? Letter C, prohibited by RESPA as payment for the referral of settlement service business. All right, so the Real Estate Settlement Procedures Act, which is RESPA, you're going to learn about this in your financial legislation section. You'll see that in, could be the closing disclosure section or something like that, closings and settlements. You'll see it there. And it generally prohibits the giving or accepting. This is important. So if you're giving or accepting a kickback is something of value for the exchange of a referral of business on federally related mortgage settlement services. So, federally related means like residential transactions. Generally speaking, there's a few catch-alls, but you don't need to know the specifics. For your tests in real estate, you just want to know that RESPA covers covered transactions, generally speaking, residential transactions, your garden variety residential, like your single family residential transaction. And if somebody offers a kickback or accepts a kickback, hey, a mortgage lender says, look, for every referral you give me to write the loan, I'll give you $150 like they did in this question. That's a referral fee that they're paying for this business referral. And whether it closes or not, they're still getting paid that, or they're still paying that out. That's a kickback. Now, a lot of folks go, well, what's the difference? What's the big deal? Kickbacks in the mortgage lending business are really hard to understand where they're coming from. And so why couldn't I charge or upcharge a consumer a little bit more money for processing to pay the kickback? I'm not going to pay it out of my pocket. I'll just pad it on the fees and make somebody else pay for it. And so these are prohibited because they could adversely impact the cost of the transactions for settlement services. So they're prohibited. There's a section in this law called RESPA that says no way. It's Section 8, by the way, but you don't need to know that. Payment may be allowed for legitimate services that are reasonable rate, but here the payment is tied to referrals and no actual service being performed. That's the sort of the operative statement. Payment has to be tied to referrals, and you could legitimately get a referral fee for referring business, but it has to be a net benefit to the consumer. Question number 13. A buyer makes an offer to purchase a property. Before the seller accepts it, the buyer properly communicates that the offer is withdrawn. The seller then attempts to accept the original offer. Which statement is correct? Letter A. No contract was formed because the offer was revoked before acceptance. Letter B. A binding contract was formed because the seller accepted the offer. Letter C. No contract was formed because all offers automatically expire after 24 hours. Letter D. A binding contract was formed because real estate offers cannot be withdrawn. And the answer? Letter A. No contract was formed because the offer was revoked before acceptance. So contracts. It makes up the biggest section of most examinations all over the United States. Study your contracts. And the explanation here is an offer may generally be revoked at any time, revoked at any time before it is accepted, unless an enforceable option agreement keeps the offer open. Once the buyer's revocation has been communicated, the seller can no longer accept the original offer. Pretty straightforward. Great question. Question number 14. A 17-year-old enters into a contract to purchase a vacant parcel of land. Which statement best describes the contract? Letter A. It is valid only if the seller was unaware of the buyer's age. Letter B. It is automatically void. Letter C. It is unenforceable by either party under all circumstances. Letter D. It is voidable by the minor. And the answer? Letter D. It is voidable by the minor. So, the trigger here is a 17-year-old, somebody not of contractual capacity, enters into a contract. So I'm automatically thinking this has got to be a voidable style question, for somebody that's a minor. That's usually a very popular line of questioning. A contract entered into by a minor is generally voidable at the minor's option. This means that the minor may usually disaffirm the agreement, while the adult party may remain bound unless the minor chooses to cancel it. So anytime you see somebody underage, under the age of 18 is typically the age of contractual capacity in most jurisdictions in the United States, you're automatically thinking voidable by the minor. Question number 15. Which agreement would generally need to be in writing to be enforceable under the statute of frauds? Letter A. A verbal request for information about a listing. Letter B, a contract for the sale of real property. Letter C, an open listing agreement with multiple brokers. Letter D, an agreement to show a property to a prospective buyer. And the answer? Letter B, a contract for the sale of real property. So, the requirements of the statute of frauds, which is something that you learn in your contract section, is that contracts involving the sale or transfer of an interest in real property generally must be in writing to be legally enforceable. That's by the courts. Its purpose is to reduce fraud and misunderstandings by creating clear written evidence of the parties' agreements. So, per the statute of frauds, real estate contracts, generally speaking, the buy and the sell piece, needs to be in writing in order to be enforceable. Now, the only exception here is a lease for under a year in many jurisdictions can be still oral versus in writing. Best to put everything in writing. But for the sale of a parcel of real estate, the statute of fraud says that it has to be in writing in order to be enforceable by the courts. Question number 16. A seller accepts a buyer's offer but changes the proposed closing date before signing it. The seller's response is considered letter A, a unilateral contract. Letter B, an option. Letter C, a counteroffer. Letter D, an acceptance. And the answer? Letter C, a counteroffer. So, an acceptance must agree to the offer's written terms without changes. That's the sort of operative phrase there, without changes. Changing anything, like in this case, they changed the closing date, is a counteroffer, which rejects the original offer and gives the original buyer the choice to accept, reject, or counter yet again. So you want to know your offers and acceptance versus counteroffers. Question number 17. Which deed provides the greatest protection to a buyer because the grantor makes warranties covering the property's entire ownership history? Letter A, general warranty deed. Letter B, special warranty deed. Letter C, bargain and sale deed. Letter D, quitclaim deed. And the answer? Letter A, general warranty deed. So, the general warranty deed provides the broadest of warranties of title. It has a bunch of them, 5, some 6 in some jurisdictions. A grantor promises to defend the buyer, the seller, promises to defend the buyer's title, if buyer's the grantee, against claims arising both during and before the grantor's ownership. A special warranty deed, to contrast, generally covers only claims arising during the grantor's ownership. So if, this were the day of purchase and this was the day you were purchasing it, the seller, if they sign a general warranty to saying, I will guarantee it from the time that I bought it, even back to the time that somebody else bought it, theoretically to the beginning of time, and defend that claim if anybody were to come up to affect you buyer. So, which type of deed offers the most protection to the buyer or the grantee? The general warranty deed. So you want to know that, and you want to know that it has all of the covenants inside of it. Deeds will definitely be on exams. You want to know these. Question number 18. Recording a deed in the public records primarily provides, letter A, automatic title insurance coverage. Letter B, a guarantee that the title has no defects. Letter C, actual notice to every person in the state. Letter D, constructive notice of the ownership interest. And the answer? Letter D, constructive notice of the ownership interest. So, recording a deed gives the public what's known as constructive notice of the ownership claim. So there's another phrase that you'll see sometimes in books that's called actual notice. All right, so there's constructive notice versus actual notice. Now, constructive notice is recording the deed. Actual notice is being able to find proof that this thing is in public records. So you want to study the definition of both. Constructive notice is the big one that you typically see when you're looking at the two of them. Constructive notice means a person is legally considered to know information available in the public records, even if that person never reviewed them. And so recording gives constructive notice of ownership interest. That's why we record the deeds. Question number 19. A city acquires privately owned land to construct a public highway and pays the owners fair compensation. The government is exercising its power of letter A, taxation. Letter B, eminent domain. Letter C, escheat. Letter D, police power. And the answer? Letter B, eminent domain. Oh, man, eminent domain is on this exam. So is condemnation. You definitely want to study this. All right, so eminent domain is the government's power to take private property for public use while paying always just compensation. Condemnation, the other phrase, is the legal process used to exercise that power. So eminent domain is the government power or the government right. So just know that those phrases, and then the legal process or procedure is called condemnation. Question number 20. A property owner dies without a valid will and without any legal heirs. Ownership of the property will most likely transfer to the state through letter A, adverse possession. Letter B, foreclosure. Letter C, escheat. Letter D, condemnation. And the answer? Letter C, escheat. So, escheat allows properties to transfer to the state or the county when an owner dies without a will. That phrase you need to know for your exam is called intestate. So without a valid will and no lawful heirs. Those two items have to be in check before escheat takes place. So it prevents properties from remaining permanently ownerless. So then we, the people, become the owners if there's no other heirs that it can go to. Okay, so escheat is a government power, and this is one that you many times will see on exams. Question number 21. Which lien generally has priority over previously recorded mortgages and other private liens? Letter A, a real estate property tax lien. Letter B, a second mortgage lien. Letter C, a judgment lien. Letter D, a mechanic's lien. And the answer? Letter A, a real estate property tax lien. So, real estate tax liens generally receive priority over all other liens. The government takes priority over all. So the government is a super lien holder, and they get automatic priority. Most other lien priorities are determined by recording date, often summarized as first in time, first in right, except the government, they jump right in front. And in some states, if it's a mechanic's lien, it could also jump the priority line. So you want to check your states, but they are looking for government and liens, and they want you to know that it has super priority or jumps in front of priority one. Question number 22. A borrower has a fully amortized fixed rate mortgage. Which statement is correct? Letter A, the interest rate changes according to a financial index. Letter B, the entire principal balance becomes due at the end of the loan term. Letter C, the borrower pays only interest during the first several years. Letter D, regular payments gradually repay both principal and interest. And the answer? Letter D, regular payments gradually repay both principal and interest. So the question is, a borrower has a fully amortized fixed rate mortgage. Which statement is correct? And so with fully amortized mortgage loans, Each payment includes a little bit of principal and a little bit of interest, a lot of bit of interest in the first stages, and then it kind of balances over, and then it goes towards principal, and the loan balance is reduced to zero by the end of the term. Early payments contain more interest, while later payments contain more principal. Question number 23. A borrower obtains a $300,000 mortgage and pays 2 discount points. How much will the points cost? Letter A, $12,000. Letter B, $6,000. Letter C, $3,000. Letter D, $9,000. And the answer? Letter B, $6,000. So points are definitely on exams, discount points, regular points. 1 discount point equals 1% of the loan amount. So 1% of the loan amount would be $3,000. And they paid 2 discount points, so that's times 2 equals $6,000. Points are calculated using simply the loan amount. Remember, never the property purchase price. And sometimes what they do is they will throw in different numbers, the red herring numbers based off of the property value, etc. Make sure you watch out for that. It's always off of the loan amount. Question number 24. A buyer and seller enter into a valid purchase and sales agreement, but the transaction has not yet closed. During this period, the buyer generally holds letter A, legal title. Letter B, equitable title. Letter C, a leasehold interest. Letter D, title in severalty. And the answer? Letter B, equitable title. So, once a valid sales contract is signed, a buyer generally receives something known as equitable title, meaning the right to obtain legal ownership once the contract terms are completed. But when we close, equitable title becomes legal title or full title. So think of equitable title like sort of ownership light. I promise that you will own the property subject to you completing everything in the contract, the seller says to the buyer. But because we signed this contract and I intend to sell to you, you have equitable rights. Equitable means based on fairness. I'm going to give you the deed once you give me the money. And that's what the settlement's all about. The minute you give me the money, you get the deed, and that's done at the closing table. So at closing, the title will convert to legal title or full title. And during the interim in the contract phase, the buyer has equitable title. This is a tricky concept for a lot of students, but it's an important one to understand. You need to know the phrase equitable title. You'll also see this with trusts. You'll also see it with deed of trusts. And then you will also see this with installment contracts, all 3 of which I know with a high degree of certainty that you're going to see these on exams. So you want to read through these, look at this question, look up the phrase equitable title, and you'll be good to go. Question number 25. A home has only 1 bathroom, while similar homes in the area typically have 2 or 3. This loss in value is best classified as letter A, physical deterioration. Letter B, economic obsolescence. Letter C, functional obsolescence. Letter D, appreciation. And the answer? Letter C, functional obsolescence. Functional obsolescence is a loss in value caused by some kind of outdated or undesirable feature. In this case, 1 bathroom, where most of the homes have 2 to 3. And that makes the property with 1 bathroom less valuable in a way because of the functional obsolescence of not having more than 1 bathroom. So an inefficient layout, like in this case, too few bathrooms. So physical deterioration results from things like wear and tear, while economic obsolescence is caused by outside influences. It could be high crime in an area, etc. And nearby noise or declining neighborhoods also would be external or economic obsolescence. So these three are legit ones: functional, physical, and economic. Functional obsolescence is the answer to this question because the property is suffering from some kind of a defect, not enough bathrooms, right? That's a functional obsolescence. The physical deterioration could be it has something that reduces its value, like it's really old, it's got old carpets, it needs to be updated and painted. And so there are curable versus incurable. Like maybe we could put in another bathroom in that property. So that could be a curable functional obsolescence. It's curable, and once we cure it, then the property value comes up more in line with the other properties. The only one that's incurable, by the way, is economic or external, because you can't really change the crime in the area, let's say. So, the reality here is all of the others, the other two, I should say, are curable versus incurable, and then economic obsolescence is always incurable. You want to know these? You'll see these in the cost approach to value in the appraisal sections of your books. Check it out. You're going to see these. All right. If you're looking to pass the real estate examination in less time, you're also going to need to nail vocab. So check out these real estate flashcards in the next video, and I'll see you in there.